The next matter to come before the court this morning is Travis Rice versus Alysha Sobel. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve that time and you're the appellant, let me know when we get started because I'm keeping the clock this morning. We've read the briefs. We are ready to proceed when you are.
All right. Good morning. May it please the court, Your Honors. My name is Travis Rice. I'm also the pro se litigant in this case. We're here today to review 3 assignments of error found from the trial court and also represent my daughter in this case as well.
Mr. Rice, would you like to reserve any time for rebuttal?
Yes, ma'am. Thank you for asking that. 2 or 3 minutes rebuttal should be fine, Your Honor. Just a quick review of the case before we get started in the assignments of error. Right now, current visitation is scheduled for 1 week in a month, and also child support obligation is currently $299 a week, which roughly $300 a week adds to $15,600 annually for 24 days a year visitation. Okay.
Was that new, changed? You're telling us what it presently is.
Yes, ma'am.
Are those the same numbers and facts as in the appeal?
Yes, the
Okay, all right.
so those are really 3 main issues is more visitation time, child support deviation, and also the presence of the smoking issue. Okay, so the first assignment of error. My opinion, the child court abuses discretion by not considering the shared parenting plan as being in the best interest of the child, even considering the fact that the court-appointed guardian ad litem endorsed more visitation time, stating that the father should have parenting time on a graduated schedule of increasing duration. That's on the transcripts, page 111 at line 23-25. It's also on page 88 on that of the brief there on the magistrate's decision page. Although this is one factor to consider under the Ohio Revised Code 3109.04F, the other factor I wanted to also bring to the court's attention is under the Ohio Revised Code 3109.051, which declares the state's own progressive visitation schedule as well. You notice there, these are. Anybody can pick these up in the office downstairs, and there's 4 sections there, each one with a graduated visitation schedule. And currently my daughter just turned 3 January 22nd, so she falls in that 3rd category, which allows for the most progressive visitation of 8 days, roughly a month, until she gets to the next one, which is the age of 14 or older, which she's allowed to declare who she wants to live with. Okay. The last thing I will say on that assignment of error is that in my opinion, the court failed to. They did make a decision on the current visitation schedule as of 1 week in a month, which has stood from the very first hearing I ever set foot in February 2013. I did not see any kind of determination if there will ever be a progressive visitation schedule. I don't think that was addressed from the court going forward. So I'm really unsure if the 2 days a week, or 2 days a month, sorry, is going to be from here to the end of time, or if a progressive visitation schedule was determined to never not going to happen. For the second assignment of error, the court abuses discretion by ordering my house off limits due to secondhand smoke exposure, even though testimony revealed that the one person who smokes does not do so in the presence of my daughter or any other child in the family. I just want to point out one case law here. In regards to Julie Ann,
It's not clear to me that this person who doesn't smoke in the child's presence smokes in a residence in which the child is present.
Yes, ma'am. There's no doubt, I'm not denying, I'm a registered nurse myself, been so for 5 years now. I'm not denying secondhand smoke and the detrimental effects it can have on
Yeah, the
kids. or any-
lingering effect, even though the person has not smoked in the physical presence of the child.
Right.
Okay.
My question to the court is, if a child's born to parents who are smokers, is that child not allowed to live with them? Even if the pediatrician and the courts say, especially in the case regarding Julianne, family courts can protect our children by issuing court orders as standard practice restraining persons from smoking in the presence of children within its care. Also, the pediatrician for Ashton did make recommendations as far as regards to smoking caretakers, and that's was presented by the appellee, exhibit I-1 in trial court. And the recommendations from the pediatrician are to advise smoking caretakers to wash their hands, change clothing, and/or smoke outdoors to help prevent any kind of secondhand smoke exposure and contact. The only reason why I'm not asking for my daughter to live in that household, even though I currently do, the only reason why is to help alleviate financial expenses due to the current child support obligation, my current bills. We'll get to that in the 703 error, but and also to help pay for litigate the lawyers to help fight in this case. That is the only reason why I moved back in with my family to help me with this issue of trying to get more visitation. What I am asking the court is, though, my grandmother's household is a household that every holiday, every birthday is held there. And like I said, I'm not asking her to live there, but if she would be allowed to be there for an hour or so on holidays or birthdays. And like I said, my grandma has 18 other grandchildren, and the smoking thing has never been an issue with any other person. And also, I would like to say too, during the trial and stuff like that, there was testimony that there was never an issue with my grandma even watching our child while the mother and myself, went out on day nights for ourselves, or even while both of us were at work during the times that we lived together. It only became an issue after we had separated. So like I said, I'm not denying the issue of secondhand smoke there. As a nurse, I know all too well the effects of that, and I would never do anything to my daughter in harm's way. Okay, the third assignment there, court abuse discretion by not granting child support based on deviation based on Ohio Revised Code 3119.22. The current child support order does not allow for an independent standard of living that would also help me to provide myself and my daughter our own residence. As you all know, most residences usually are between $550 up as far as rent and mortgage and stuff like that goes. The current $300 a week I spend in child support, I think is an exorbitant amount of money, and let's see. Under the Ohio Revised Code 3119.23, there's factors to be considered when determining a deviation in child support, such as the following factors that I've highlighted to apply to this case. Under letter L, it says the standard of living and circumstances of each parent and the standard of living of the child would have enjoyed if the marriage had continued or they had previously been married. Obviously, if we were still together today, there would be one house payment. The daycare cost would be shared by both parents, or the family that I have also was alleviating daycare costs by allowing us to have my daughter stay with my aunts or my grandma while we were working, which would also alleviate daycare costs. The mother chose a daycare that doesn't allow for anything but one monetary amount per week. Whether you use 1 day, 2 days, or all 5 days, it is a set fee for that daycare, and in such, that daycare cost was $253 a week, which is about $1,000 a month, which totals to $12,000 a year, which is also something that she's allowed to take into consideration for her expenses when it comes to taking that off and reducing her income, which also raises my child support obligation. Now, my current obligation covers that expense entirely. So basically I'm paying for somebody else to watch my kid, or help even raise my kid for that matter, and I'm only entitled to 24 days for an entire year. Okay. Also in that section too, it says, if the court will allows extended parenting time, this is under letter D, in the same Ohio Revised Code 3119.23. Under letter D, it says extended parenting time or extraordinary costs associated with parenting time, provided that the division does not authorize and shall not be constructed any authorized deviation from the schedule and applicable worksheet. The extended parenting time, if I do down the road am allowed extra visitation with my daughter, more funds will be needed to pick up the cost for the food and the clothing and the housing for those extra days. Not to mention also the 6 hours driving from, it's actually 6 hours from here, from Akron to Philly, even though we meet halfway, okay? We meet halfway in Snowshoe, which is 3 hours, and we drive back 3 hours. So it's still a 6-hour drive for the parents. Now, those costs are also, for gas costs and food costs during those trips. That's also an extraordinary cost that would not have existed if both parents had lived in the same area or if mom had not moved out of state.
And you are just now reaching to your 3 minutes of time. You may continue or reserve as you wish.
Okay. I do want to thank you guys for your time today. Like I said, the main issues here are just, to be a father for my daughter. I love her very much, and there's no doubt about that. I've spent numerous times even going to Philadelphia to alleviate that travel time, because you guys all know you've been on a flight before, you've heard jet lag, you've obviously probably heard of car lag too. That 6 hours drive really takes its toll on the alertness and visitation you have to spend with your child. And I have it right now 1 week in a month. 2 days is spent in the car driving, so I have it for 1 full day where we're not actually traveling. And I don't know what the effects of that is on my daughter at this stage of her development, as far as sitting in the car for 6 hours, but I feel bad having to put her through that. And if extra visitation time was granted, if that could be bunched together as well to alleviate the multiple travel times, that would also be greatly taken into consideration. I want to thank you guys for your time today.
Good morning, Joshua Lemmerman of Goldman and Rosen on behalf of the appellee, Alysha Sobel. I co-prepared the brief with my colleague, Mr. Gary Rosen. I want to impress upon this court that in this case, it was very straightforward with regard to the witnesses that were heard and the choices that the court had to make. They heard from the parties, they heard from Mr. Rice's paternal grandmother. The court heard from a GAL and a family court services worker. And from that evidence and testimony, it reached really the only conclusion that it could, that residential parentage with Ms. Sobel was appropriate and in Ashland's best interest. What we really need to focus in on is that this was a modification case. Mr. Rice had already had a prior court order that had restricted Ashland from being exposed to certain households with regard to cigarette smoke. That was already known
I
to the
do
court.
have a question about that. In a normal family where the parents smoke, there's no question with the child with the same physical asthma or similar problems, the court has no ability to control that child's environment.
If they were co-parenting
If
in the
they're
same home.
co-parenting, right. So in this case, the court can preclude the child from visiting with one of the parents in the parent's home if the parent were a smoker.
If the parent were a smoker and the parent would not desist from smoking or having that child be exposed to secondhand smoke while in that home, then the court would be within its rights, as per Henry Julian,
Okay.
to restrict the access to other places where it would be helpful for the child. And this is not just for,
The counsel, the
Yes.
second part of that answer and analysis in that case is exposing the child to secondhand smoke.
Yeah.
Wherein this order says the father shall not have a child in a smoking residence at any time during his parenting time in Ohio, including Mrs. Rice's house.
yes,
So even if Mrs. Rice is not there the entire weekend, her house has been designated as a smoking residence, so the child cannot stay there or go there for a limited period of time. The case law that you had cited in response to Judge Whitmore's question always continued to add the exposure to secondhand smoke. So I guess I'm wondering, we don't have a definition of what a smoking house is or smoking residence, correct?
well, in this particular case, we did, because the testimony from the witnesses at this hearing helped to illuminate what the court had already known from prior hearings, which was that there is significant smoking going on in that household, and it's not helpful for the child. She has respiratory ailments. There was a lot of debate in this case about whether it constituted asthma, but the medical professionals in the GAL reported about there being reactive airway disorder or respiratory conditions. This went back from when the child was very young. It was known to everyone, but in this instance, Mr. Rice wasn't communicating with the pediatricians to learn about it, was minimizing or disregarding any potential risk, and even now is essentially trying to lump Ashland in with all these other grandchildren who are not before this court and who don't have any asthmatic or pre-asthmatic condition. This court, in this situation, heard the evidence, had known that this house was not appropriate for Ashland, and had designated places where Mr. Rice and Ms. Sobel had understood were helpful environments where there wasn't smoking going on, so it took that precaution to protect Ashland. And still, the testimony that this court heard, even after that was already in place, was that Mr. Rice still brought Ashland back to that home and to another relative who had not been pre-cleared by the court, even though that court had already taken the step to designate what would be good places. There was even another outlet, which was that the parents could agree on an additional other relative's home that Ashland could stay with Mr. Rice. But Mr. Rice didn't try to seek any permission or even communicate that option to Ms. Sobel. He just took it upon himself to take Ashland to some other cousin's house because he wasn't being mindful of the court order. I don't know if he was able or willing or if it was just our disregard. But this is really what was the crux of the guardian ad litem's opinion, was that he would not be trustworthy to abide by the court's orders because he was showing such skepticism about the seriousness of Ashland's condition.
But it said that, did it not, that perhaps if he cannot be trusted, that supervised visitations would be in order, but those weren't ordered.
That's correct, but it went to that level. Mr. Rice wanted this court to take what was really an out-of-context recommendation by the GAL about some future graduated increase in access time for him, but that is really ignoring the lion's share of the GAL's recommendation, which was that residential parentage should remain with Ms. Sobel for the present, and that indeed, if he continued to not be able or willing to abide by the court's orders keeping Ashland from non-smoking residences, that he should only have supervised visits. Now, that's not something that the court suggested, and frankly, the GAL said that just should be considered. But that was the level at which the GAL was showing concern about the way in which Mr. Rice was taking care of Ashland in the situation, or failing to do so.
Was there testimony about any untoward physical, manifestations that were observed in the child after being in the quote-unquote smoking home, and wheezing, and he testified, he said, well, whenever the child leaves there, they're teary-eyed and that kind of thing?
Your Honor, I can't recall, if only because we've gone through this process for almost another year and a half since this particular transcript, and there has been testimony over the course of many hearings with regard to adverse health effects that Ashland suffered. So I would need to reconsult the transcript at this time about whether it was specifically testified to back in October 2013. But this has been an ongoing concern. It was a concern then. It had been a pre-existing concern since it was a modification case, and it still hasn't been alleviated to the point where, as Ms. Sobel had already testified in this particular hearing, she was enclosing a monitoring device, a global positioning system, just because she had already been, it had been indicated by Mr. Rice that he was going to take her to places that the court hadn't pre-cleared, and that's exactly what was happening. So it really does come back to what the court heard, especially from the guardian ad litem, and I'll quote directly from the transcript on this issue, that Ms. Sobel has been the primary person who's taken Ashland to the medical professionals to assist her in her physical issues. She's been the one to interact with the daycare and educational needs of the child to this point. Mr. Rice has not stepped in to even get information on that. He, as you heard him say, doesn't believe she has asthma, doesn't believe what the medical professionals are saying, and I'm afraid he will not be capable of making those decisions. Now, in light of that recommendation, this court really didn't have a choice. It was very straightforward. That residential parentage belonged with Ms. Sobel. If Mr. Rice could show greater mindfulness of Ashland's asthmatic condition in the future, then perhaps that graduated schedule, which has been taken out of context, that might be considered. But really, this court was hearing from everyone that it tipped the other way. That Ms. Sobel had been the reliable, stable parent who moved the child to Pennsylvania, not just because of the unhelpfulness of the environment, but also because of domestic violence for Mr. Rice. There was a protective order in place, and because her family lived in the Philadelphia area where she could be supported. As to the child support issue, since I know we're running short on time, there is no cause for a deviation here. It might be one thing if Ms. Sobel were to have just moved out to that Philadelphia suburb and never come back and said, I'm done with Ohio, I'm done with Mr. Rice. But that wasn't the case at all. She's been more than accommodating, as Mr. Rice testified or spoke here. They were, even at that point, meeting halfway in western Pennsylvania so that there wouldn't be a disproportionate burden on either of them with regard to the travel costs.
Was that by court order, or was that just...
No, that was because the parties agreed to do that, because Ms. Sobel understood that she had gone that way. So there was an equal burden with regard to that, and there's no reason for the court to have deviated from the child support guidelines, which, with respect to Mr. Rice's monthly expenses, those aren't part of the analysis. Whether he has a certain utility bill or a monthly mortgage, it's with regard to the child, their respective incomes, and it's also not tied to the amount of days per month or per year that he has access ordered. It's regard to incomes, and that's what it's based upon. So there was no cause for deviation here. So I'll conclude by saying that, as this court knows, the trial court has broad discretion in parentage cases to evaluate the credibility of the witnesses And absent an abuse of discretion or an unreasonable or arbitrary decision, this court should uphold the judgment of the trial court, and I would ask the court to do so. Thank you.
Mr. Rice, you have a minute and 35 seconds for
No,
me.
that's fine. I just got 2 points. You are. I just want to touch on 2 things here. Plaintiff testified that I had my daughter in, or I'm sorry, the appellee's attorney testified that I had my daughter in a house that the parties kind of agree on. On page B5, which is very close to the end of my brief, under line number 26, the court order from the Judge Quinn states that the plaintiff should not have a child in a smoking residence at any time during his training time in Ohio, including Mr. Rice's house. It does not specifically say whose house the child is allowed to be at, just not that residence. The other thing I want to point out is also in regards to being more involved with the doctors. While I was over there, the only doctor's information I'm allowed to obtain is the information. I have doctor's reports in my bag right there that show that the only information I'm allowed to obtain is actually when I physically went to the doctor's office. Anytime I speak to her doctors over the phone, the nursing staff and stuff, they say, can't you get information from her mother? You know, I feel really uncomfortable, you know. And in one doctor's office, they told me that they're not authorized to give me information to me. And as far as communication with the mother, you know, sometimes she communicates, most times she don't. So in the instance of a doctor's information, she says, I've already given doctor's authorization to give you the information. But I'm still finding resistance with the doctors unless I'm actually physically in the doctor's office and they see me. That's the only time I've been able to obtain any kind of medical records for my daughter.
And with that, I'm afraid you've reached the end of your rebuttal time as well. Thank you
Thank you,
all
Ron.
for your presentations this morning. Court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website, the Ohio Supreme Court website. Thank you.
Thank you.
Thank you.